Welcome to today's new episode of our IP Insights. Today we want to focus on the costs of prosecution of a unitary patent and of litigation before the Unified Patent Court.
Well, Georg, please share your thoughts on the prosecution costs of the unitary patent.
Well, good question. That's a good starting point for our discussion today. So the costs for getting a unitary patent are essentially the same as for the classical European patent. The only difference is you have to file a request for unitary effect for which there's no official fee. Afterwards, these are two separate stories. So for the unitary patent, you will have to pay a single renewal fee at the European Patent Office, which is about the same you would have to pay for a European patent validated in 4 member states, namely Germany, France, the UK, and the Netherlands. This is typically called the true top 4 approach for the renewal fees.
But I do get much more for my money than just those 4 countries, don't I?
Absolutely. So you will get protection in initially 17 member states of the European Union, and as the system goes and new EU member states will join the system, you can get protection in up to currently 26 member states.
But I heard criticism about the new system because it doesn't reflect that the UK is now no longer part of the system.
Yes, this criticism is around. So when you think about a typical validation scenario where you would validate your European patent in, say, Germany, France, and the UK, the costs for using a unitary patent would be higher than going the classical route, because you would have to have a unitary patent for covering Germany and France, and you would have to have a separate UK validation. But if you compare it with a scenario where you would like to have protection in more countries, this cost increase may decrease. So roughly speaking, depending on the math you do, you would have a break even for the unitary patent if you want to validate it in 2 more member states compared to the example I just mentioned.
Okay, so I'll pay for those 2 more and I get the rest free, basically.
Yeah, that's basically the situation. But Alex, what about the litigation costs now before the UPC?
Good question. So for evaluating the litigation costs, we will have to look at the court fees and the recoverable costs.
Well, being a patent attorney, I would be curious to know whether the costs for filing a revocation action at the UPC will be significantly higher compared to costs of a German nullity action, because many more countries may be affected.
Well, Georg, you can rest assured that is not the case. Indeed, if you file standalone revocation action at the central division, or if you file a counterclaim for revocation at your local or regional division that handles the infringement proceedings, the court fees for such an action will not exceed 20,000 euros. They can be even lower if the value in dispute is lower.
Well, that's wonderful news. But what about the costs for filing an infringement complaint at the UPC?
Well, for infringement proceedings, you will have a fixed fee and a fee that is depending on the value in dispute of the proceedings. So it can reach higher values, but not necessarily. For example, a value in dispute of 1 million euros would lead to court fees of 15,000 euros.
Well, these numbers are really low compared to the national court fees, which makes litigation at the UPC really attractive for plaintiffs, right?
Indeed. There are also mechanisms in place to reduce these costs even further for small and medium-sized enterprises. They can get a reduction of up to 60%. Furthermore, an early settlement is encouraged because it will also lead to a reduction of court fees.
Now, what about cost reimbursement? In the German system, cost reimbursement applies, but the actual cost reimbursement is often much lower than the actual costs of infringement and invalidation proceedings. Will that change the UPC?
Yes, indeed, Georg. This will change dramatically because with the new system, it is possible to claim your actual costs in contrast to what we now have with the national systems where you can only claim your statutory fee schedules. However, this will also increase the risk for parties participating in the new system.
But there must be some kind of cap, right, to these actual costs?
Well, indeed, there is something called a ceiling to these recoverable costs. But don't worry, these ceilings are exceptionally high, I think, at least from a German point of view. For example, in the 1 million euro value in dispute case I mentioned, the ceiling for the infringement proceedings alone would be 112,000 euros. But usually it would be the case there is like a revocation action in parallel or a counterclaim for revocation. And that leads to the fact that those two values and disputes get added, and it can be 150% of the infringement claim. Now, those combined values lead to a ceiling of 400,000 euros.
Well, that sounds very attractive. So if you compare to the German system with the same value and dispute that you mentioned, 1 million, the recoverable costs for nullity and infringement proceedings would be less than 60,000. So I think we're talking about a completely different number here. If we sum up, so the UPC offers significantly lower court fees compared to the German system, and at the same time, significantly higher recoverable fees, which in combination should make the UPC a really attractive venue for patent litigation. Thank you very much for watching this episode. If you want to know more about the costs of a unitary patent and litigation before the UPC, please visit our UPC special on our website, watch one of our related videos, or register for one of our webinars on the UPC.